This video is intended to familiarize you with court procedures and does not offer legal advice. The court assumes no responsibility for actions taken by the viewer of this video. You may need to ask the court to appoint you as a conservator for a minor when a minor receives a settlement from an insurance company following an auto accident, when a minor receives an inheritance, or when a minor receives money that needs to be held in trust. This video will list the steps you must take to be appointed as a conservator to a minor, including forms you will need to complete, where to find the required forms, filing the documents with the clerk, giving legal notice, what to expect at the court hearing, your duties following the hearing. You can pick up the documents from the self-service center or print them online. Complete everything but the case number. It will be given to you by the clerk of the court when you file the papers. You will use this case number on all future court documents. The probate information sheet contains personal identifying information about the petitioner and the minor. The petition explains what you want the judge or commissioner to do and why. You will answer a series of true-false questions about your background and history. This document must be completed and signed by both parents of the minor, if they are living and have not had their rights permanently severed. If you can find only one parent, have that parent sign the consent. Or, if you are not able to locate either parent, be prepared to explain to the judicial officer at the court hearing why neither parent, or only one parent, signed the consent. Also, you will have to prove to the court you did everything you could to try to locate the parents. After preparing the appropriate paperwork, you will need to bring in the original documents and 2 sets of copies to the clerk of the court. There are 4 locations of the Maricopa County Superior Court. Phoenix, 125 West Washington Street, 1st floor. Northeast, 18380 North 40th Street. Northwest, 14264 West Tierra Buena Lane. Southeast, 222 East Javelina, 1st floor, Suite 1350. There are fees for filing petitions, responses, requests, motions, objections, and the various forms with the court. The clerk of the court accepts cash, Visa, or MasterCard, money orders, or personal in-state checks made payable to the clerk of the court, care of the probate registrar. Go online or to the self-service center for a list of current fees. After you have completed and filed the petition and the other court papers with the court, you must tell all interested persons about the papers in the court hearing at least 14 days before the hearing. Give the people who are entitled to notice the following documents: notice of hearing, petition. Remember, this document explains what you want the judge or commissioner to do and why. There are 2 ways to give legal notice. First is by personal service, which includes personal delivery, process server, and the sheriff's office. Personal delivery. You can hand deliver the papers yourself. The person must sign the acceptance form in front of a notary and return it to you, but the signature date cannot be earlier than the date you filed the court papers. This signature on the form does not mean the person agrees with the papers, just that they have received them. If the parents of the minor who need protection can be found within the state of Arizona, they must be served personally. Process server. Generally, you must pay this person or company to do this for you. A process server will give the papers to the person at home, work, or other location. The process server will give the court a sworn affidavit stating that the person was served. Sheriff. You can contact the sheriff's office in the county where the person lives. This method requires you to arrange for a sheriff's deputy to serve the papers. You will be required to pay a fee to the sheriff's office unless you receive a waiver or deferral, which is available through the court for persons who cannot afford the cost of service. The second way is by mail. You can send the documents by first-class regular mail. If the parents of the minor who need protection live outside of the state of Arizona, you can give notice by mail or publication. If you cannot locate a party, you can request that the court allow an alternative means of notice, such as publication in a newspaper. You must seek the court's permission before using this alternative. Notice must be given to any person serving as guardian or conservator, any person who has the care and custody of the minor who needs protection, any person who has filed a demand for notice with the court. After you've filed your documents, paid the required fees, and given legal notice, it's time to request a hearing date. Probate Court Administration sets the date, time, and place of the hearing and assigns the judicial officer as well. You will need to bring the following copies of the stamped documents: probate cover sheet, petition for appointment of conservator, affidavit of the person to be appointed, consent of parent, and instructions and request for hearing date. To the probate registrar's office located on the first floor of the old courthouse at 125 West Washington Street in downtown Phoenix. You can also schedule a hearing by phone. Call 602-506-5510 3 to 5 business days after the case was filed. At least 10 business days before the scheduled hearing, you will need to take the original and 2 copies of the notice of hearing, the proof of notice, and any waiver of notice or acceptance of service to be filed with the clerk of the Superior Court. You will receive these documents from the probate registrar when you schedule a hearing. At this time, you must also complete the order to conservators and the order of appointment. Take 1 copy to the probate administration and deliver 1 copy to the division who will hear your case. Also, at this time, notify court administration if you need an interpreter at your hearing. At the court hearing, the Commissioner will review your documents, hear the testimony, and rule on your petition for minor conservatorship. You will need to bring 2 copies of your petition, notice of hearing, proof of notice, order to conservators, orders of appointment, letters of appointment, and acceptance of letters of appointment to your court hearing. The Commissioner will ask you a number of questions. Be prepared to testify about why you think the conservatorship is needed. If the Commissioner grants your request, he or she will sign the orders and appoint you as conservator. They will also set a compliance calendar hearing date. After you have been appointed, there are still a number of important tasks for you to complete. The Commissioner will list your duties in the orders and also the compliance calendar notice. Go to the clerk, probate registrar, and bring the originals of the order of appointment of conservator, the letters of appointment of conservator, and the acceptance of letters of appointment. The registrar will review the order of appointment, complete the letters, have you sign the acceptance, and file the originals. You should ask the clerk to certify a copy of the letters to prove that you have the appointment and the authority from the court. There is a certification fee plus a copy fee per page to do this. If the judge ordered you to put some or all of the person's money into a restricted account, obey this order right away. Take the money and a certified copy of the letters of appointment to a federally insured bank or financial institution and tell the staff that you are a conservator under court order, you want the money placed into a restricted account, and show the staff a copy of the order authorizing restriction. Then, have the manager at the bank or financial institution sign the proof of restricted account, which must be notarized, and bring the original to the court to show that the account was properly established.